outwit the Burnett County Board. I'm going to outwit Judge Mogan and Attorney Anderson. That's what you thought. You thought you're smarter than everyone else in the room. You are not smarter than anyone else in the room. I was number 2 out of 105 people in my law school graduating class, okay? I know how to analyze the law.
What happens when a property owner believes he has found a legal loophole to bypass a court order? In this explosive courtroom battle, a landlord's attempt to continue running a short-term rental despite a permanent injunction leads to a dramatic showdown with the judge. After admitting he rented the property without the required permits, the owner faces tough questions, mounting evidence, and a shocking courtroom decision that could change everything. Watch as the judge breaks down the excuses, exposes the alleged scheme, and delivers a powerful ruling on whether ignoring a court order has consequences.
On October 4, 2024, Judge Mogan of the Burnett County Circuit Court in Wisconsin issued a permanent injunction against property owner Carl Alexiams following a civil dispute with his neighbor, Rick Brimacombe. The core basis for the lawsuit rested on the property's land use classification. Because the home is situated in a residential neighborhood rather than a commercially zoned district, operating a high-turnover vacation lodge constituted an unpermitted commercial business that created a private nuisance, infringing on neighboring owners' peaceful use and enjoyment of their land. Consequently, the court order explicitly prohibited Mr. Elysiums from operating a short-term vacation rental at his residential property unless and until he secured a mandatory state lodging license from the Department of Agriculture, Trade and Consumer Protection, known as DATCP, along with a Burnett County rental permit. Despite the binding judicial order, Mr. Elysiums continued offering his property on hosting platforms throughout the summer of 2025. In response, Mr. Brimacombe filed a motion for civil contempt, alleging deliberate and repeated violations of the injunction. Additionally, Mr. Elysiums filed a motion to stay the court's order pending appeal, seeking to halt enforcement while the appellate court reviewed the ruling. However, the court noted that an appeal does not trigger an automatic stay. Representing himself pro se, Mr. Elysiums attempted to rely on Wisconsin statute section 66.1014 D2, specifically arguing that property owners operating a short-term rental for 10 nights or fewer per year are exempt from obtaining state licenses or local county permits.
This sets up the entire conflict. The major issue is not just a neighbor dispute, it becomes a battle between a property owner's claimed rights and the authority of a court order. The audience immediately understands that violating the injunction could have serious consequences.
That we sign it and send him a confirmation.
Okay. And when you received it, what were you in the middle of doing?
We were preparing for a week-long vacation. So we were packing our bags. I was loading the vehicles, the truck, the boat. My 5 children had dropped off their luggage and their coolers, which I usually load up in my vehicles because I have a lot more space. So I was in the process of preparing for our vacation.
Okay. At some point in time later that day, did you look at this booking confirmation rental agreement again?
I did, after my wife brought it to my attention that he had showed that part of the stay was complimentary and that we actually only paid for 2 days and that the rest was complimentary. She brought that to my attention and then I looked it over again.
Okay. Did that give you any concern?
Yes, actually a great deal. We were concerned that he may have been trying to leave himself an out to force us to leave early. Our thought was that maybe he had double booked it and was giving himself a reason to evict us early.
Okay. Ultimately, you were able to stay for the entire 7 nights, 8 days. Is that true?
Yes.
Yeah. Would you have paid nearly $7,000 for a 2-night rental?
No.
Okay. Your understanding was that you paid for 7 nights, $7,000 almost for 7 nights and 8 days. Is that correct?
This is a major turning point because the plaintiff's side begins proving that the owner may have attempted to manipulate the paperwork to stay under a rental day limit. The free days argument becomes one of the biggest issues in the case.
Okay.
Right. So I went ahead and rented my property for 10 days for this past summer, 2025.
All right.
One of the,
So I'm hearing right now, I just have to make sure, you are admitting and stating on the record you've rented it for 10 days.
correct.
All right.
And with, I'm looking at Exhibit 4. What I did is I said that 2 days of the 7 were paid and the other 5 were complimentary to kind of save 5 of the 10 days. So of this, for Mr. Bennett, I'm counting 2 of the 10 for that purpose.
Okay. Got it.
And that's what's shown here on the rental agreement.
All right. So then go forward and tell me, continue to go down, tell me the days that you rented, to whom you rented it to, and we'll go from there.
I don't remember. I just specifically remember it was 10 days when you include the 2 days, the Memorial Day weekend, the Labor Day weekend. So that would be 2, 2, and Mr. Bennett is 2, that would be 6. And I think there was another rental in there. I just remember that I wanted to keep the limit at 10.
All right. And so with the Memorial Day rental, with the Labor Day rental, with Mr. Bennett, it was, you rented it per your contract or how you had written the contract, 2 days for each.
Right.
So a total of 6. So where's the other 4?
Well, we got the Labor Day, right? Did we
I already
include
did
that?
2, 2, 2. So that's 6. So there's another 4.
Let's see, that would,
Because we have the May, we have the September, and we have the July with Mr. Bennett. So
I guess what I'm saying, I kept within the 10 days. I don't remember exactly the 10 days specifically, but that was my goal or my intention, is just to stay within that 10-day limit.
all right, what else do you want me to know?
I think that's it. It's pretty basic. That's, I admit to the renting. My understanding though, it's 10 days or less. That's what the county ordinance is. That's what the state law says in the right to rental.
Okay, and so nothing else you want me to know? And what about the money issue? You wanted to argue about the money issue. Tell me about that, or not argue, tell me about that in your words, because you were saying you were trying to have other witnesses tell me about money.
Well, it's just that he's trying to argue us, if he tries to argue a sanction that I was paid $5,000, that wasn't, that all didn't come to me. There were tons of VRBO fees and taxes and things like that.
Okay,
That's just the point I was making there.
understood. So you didn't receive all the fees. Some of the fees went to VRBO and some went to taxes.
Right.
Excellent. Okay, anything else?
That's it.
Mr. Anderson?
Mr. Olson, to be clear then, you did not receive permission from Burnett County to rent your property in Burnett County, true?
I never asked them for permission.
Fair enough. Then you never received a license from the state to rent your property in Burnett County, true?
No, because my understanding is that I didn't need a license for 10 days.
This is one of the strongest courtroom moments. The defendant's own testimony creates a major problem for his defense because he openly confirms that he continued renting after the injunction was issued.
Court order. We heard testimony from Debbie Tate that they brought multiple trailers, multiple ATVs, multiple vehicles. They had 12 people there one night, 10 people there another night. We heard testimony from Mr. Bennett that there were double-digit people on the property. There were multiple vehicles on the property again. This is sort of that nuisance. It's not sort of, this is part of the nuisance that has been part of the problem. There's been more than that, but that's been part of the problem and part of the issue of how many people are renting the property and staying there when this is not a commercial property. We've also heard testimony from Ms. Tate that she was there for 2 nights, 3 days. We heard testimony actually from Mr. Alsiums that, well, I'm sorry, not from Mr. Alsiums. We have exhibit 1 that shows that the group that was there in August I'm sorry, August 28th through September 1st was there for 4 nights. It says $995 times 4 nights. We have testimony from Mr. Bennett that they were there for 7 nights and 8 days. And they booked their vacation, I think he said 7 or 8 months prior to the vacation actually occurring. And then we have a rental agreement sent to Mr. Bennett at 5 p.m. the day before they are supposed to go to the property that owned by Mr. Alsiums for their 8-day family vacation. And obviously they signed it and moved on. And then they looked at it later and saw that there was this clause in there about complimentary days. That is a sneaky way of trying to get under the 10 days, which I don't think applies anyway in this case. But even if it does, Your Honor, the point of it is they were at the property for 7 nights and 8 days. The people from August 28th to September 1st were there for 5 days and 4 nights. We're already at 11 nights between those two. And then we have Debbie Tate, who was there for 2 nights and 3 days. Now we're at 13 nights and more days. And then not even to mention the other 2 groups that were renting, one from August 8th through August 15th, which again is another 8 days and 7 nights. And the last group being June 6th through the 8th. That was the one with the ambulance. There's less information about that, frankly, but there was extenuating circumstances there. But point being, Your Honor, there were renters there in far greater numbers than 10 nights. And again, I don't think that applies, but since Mr. Alsium's arguing it, I feel like I should respond to that because we are at 13 nights just for the 3 groups that have been proven here today in court without even considering the additional 2 groups. So any way you slice it, Your Honor, whether it's by what I consider the letter of the law in terms of he's not supposed to rent, period, without a license or permission from Burnett County. But even if we do have if that is the law, which I don't believe it is, he's still in violation of it. So frankly, a lot of the argument from Mr. Alsiums doesn't matter because he's in violation either way. If you want me to address sanctions, I can do that. I can do that later. I would ask for attorney's fees, Your Honor. I didn't know how long today was going to go, so I'd ask for a little bit of time to submit that. But I can't do that today because I didn't know how long it was going to be.
All right. So yes, argue sanctions, and then he will have the opportunity to refute all that you've argued.
All right. Your Honor, I think sanctions are appropriate here. He's already been found in contempt of court for this very same action in the past. The court sanctioned him then. I think the court should sanction similarly. I think Mr. Alsium is right. He predicted that well because I think I did it last time. But the fees that were paid, I can do the math, but there's the $3,980 that was paid for the 4 nights in September. And then Mr. Alsium talks about service fees and tax. Well, that's fine, but the cleaning fee went to Mr. Alsium's and so did the $3,980 for that one. We can look at the one for Ms. Tate. She paid $1,990. Then she has host fees, which again would be to Mr. Alsium's service fee and tax. We can take that off. Those numbers again are fairly clear. So that's $2,380. Your Honor, we also have Mr. Bennett, and his was $5,665, which was the per night of $809.29 times 7 nights. That's on Exhibit 3. There's a cleaning fee that went to Mr. Alsium's service fee and tax. We can take those off, and that's fine. But I think that the profits and the money that was received by Mr. Alsium's are ill-gotten gains in a case like this, and those should be forfeited by him as a sanction. And then I defer to the court on additional sanctions. There was in the prior contempt order, Your Honor, there were purge conditions. Obviously, those purge conditions did not happen, and now we're here on round 2. And I don't normally expect to see round 2s on things like this, but here we are. And That's why I'm asking for sanctions as they are and attorney's fees. But again, I'd like, give me a week or two to get that to the court.
Right, and so your argument is you were arguing for sanctions. Your argument is, if I'm hearing correctly, that you are making an argument and a statement that purge conditions were ordered by the court to Mr. Olsiums, and pursuant to the court's order, Mr. Olsiums did not comply with the purge conditions. So that's one of the arguments. The second argument is you're arguing for attorney's fees to have to come to court for today and all of the related expenses to today's hearing. Plus, you are arguing to the court that a sanction for Mr. Olsiums should be forfeiting all of the funds that he did receive and profit from the rentals that you had proof of.
That is a good summary.
This scene highlights the judge's skepticism. The issue shifts from a simple misunderstanding of the law to whether the defendant intentionally avoided proper documentation while operating a rental business.
I'm going to give it to you for 30 days, but I'm only going to charge you for 1 day. But don't worry, it's going to be $30,000 for that 1 day. But I'm only renting you for 1 night. Clearly says permanent injunction until such time that you and Mrs. Olsiums, that you comply with and receive the state DATCP rental license, that you do that, and the Burnett County rental permit, and you continue to do so annually. So you stay compliant. The order does not give you authority in any way, shape, or form, to rent at all, even with the Burnett County ordinance of having, or the state, which says 10 nights or less, or 10 days or less. Nothing about that. And the court's order clearly defined all of that. I had all of that information in my order. So if I was going to give you authority to say, all right, you can rent it for 10 days or less. I mean, really, you can rent it for 20 days as long as you give them 10 for free. That's totally fine, but charge them for the 20, but you only rent them for 10. I said nothing about any ability to rent at all. It's a permanent injunction, permanent until you do those two things. All right. Until you do those two things. You did not do any of those things. Instead, you rented it. You were found in contempt. You had far more days for the rental at the last contempt hearing. So the court found you in contempt. And this hearing, or this case, you're like, I'm going to outwit the legislature. I'm going to outwit the Burnett County Board. I'm going to outwit Judge Mogan and Attorney Anderson. That's what you thought. You thought you're smarter than everyone else in the room. You are not smarter than anyone else in the room. I was number 2 out of 105 people in my law school graduating class. Okay. I know how to analyze the law. You were trying to be sneaky and deceptive, and you were trying to get away with something that is clearly not legal or correct. You rented over the 10 days again, whether it's 11 days, whether it's 13 days, whether it's 14 days, you admit on the stand and at the table it was 10 days. I rented 10 days, exactly what I said I could do in the ordinance. I did not do above. But I did give them 5 free days. Can't remember anything else, but I gave them 5 free days. So that's 15 days. 15 days you admit to. 15 days you admit to. I don't even have to go with any evidence or anything that's been filed or served by or received by the court from Mr. Anderson. You admit to 15 days. 10 you rented for money and 5 you gave for free. Even if I were Mr. Olsiums to take you and believe you, that is your understanding. And even if the court were to go, I don't think I wrote my order as clearly as I should, which I did though. Even if I took that and listened to your argument, you violated the ordinance. Free days count, Mr. Olsium. Free days are not free days, especially when you're charging $6,000 $980.48 for 2 days. What fool's gonna pay like almost $3,500 a night? A fool would pay $3,500 a night. It's absurd. It's ridiculous. And I can't believe you think that a court would fall for it. The Court of Appeals will not fall for it. I'm telling you that. They're very smart. Probably smarter than I am. They do this all the time. They're not going to fall for your shenanigans. They're not going to. You're nodding your head up and down. I don't know what that means if you're saying yes or not, but that's where we are. You violated the order again. So I do find you in contempt for these violations. Further, beyond that, you didn't follow my August 29th, 2025 order. Very, 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 very clear. $2,500 for each, capitalized each violation, parentheses 2, totaling $5,000, plus a 45-day jail sentence for each, capitalize each, violation to be served consecutively. Serve 1, serve 2, for 90 days jail in parentheses. The jail sentence may be purged. You may get out of that completely. I don't have to do it. That's good. I don't want to go to jail. On the following conditions: full compliance with the October 4th, 2024 court injunctive order. One way that you can purge it, plus the second way, full payment of the court sanctions, fines, and fees within 60 days. Court calculated it. I did it twice. I did it 3 times actually. The deadline was October 27th, 2025. October 27th, 2025. Let's get to that. That was a Monday. You had until October 27th, 2025, Monday, to pay that, to purge your jail. You didn't do that. Moreover, even still, your motion that you filed to stay all orders pending appeal was filed on November 3rd, 2025, beyond the deadline that I gave you to purge. Beyond that, it's late. It doesn't count. You may want me to stay the other decisions, that maybe the other parts of it, I guess. I don't even know, because I'm going to tell you your motion, your petition here, it's hard to understand. Doesn't even make sense. And you're just spewing things that you think and you interpret as the law, or actually what you want the law to be and how you want it to be. So you can follow it and you can do what you want. So the motion to stay is denied. I don't find that you've...
This is the emotional climax of the hearing. The judge directly dismantles the defendant's interpretation of the law and explains that a court order cannot be ignored simply because someone believes another law creates an exception.
Custody immediately. As to the other parts of the order, the court will again stay on that and we'll get it out. So you'll be remanded to custody for your 90-day sentence. You failed to purge. You did what you want.
Your Honor, can I purge right now?
No, you didn't have the money. You literally just said on the stand. Stop.
I have a credit card.
Stop. You literally said on the stand or on your table under oath, but I don't have the money. I can go back on a transcript. I can go back. You said those words.
I don't have it. I have it on a credit card though.
That's money. You could have paid it on a credit card by October 27th, 2025. But if you read my order clearly, words are clear, by October 27th, 2025, then the jail goes away. It's February 6th, 2026. Far beyond that. The court's enforcing it. You're remanded to custody immediately, 90 days. Thank you. We're adjourned. Sometime you have to start abiding by the law and orders of the court, Mr. Olsiams.
Can I purge, Your Honor? I have a lot of business and things that I wouldn't.
Well, what you can do is you can pay it and then you can write a letter to the court and then I'll consider it. But right now, my order is very clear, very clear. The purge condition was very clear. So if you would like to pay it and then you would like the court to, it's called reconsideration, you sure can do a motion to do that.
Can I do that right now?
No, you have to go up to jail.
How would I make?
Go up to jail.
At the conclusion of the hearing, Judge Mogan ordered Mr. Alicium.
This is the most viral-worthy moment of the entire video. The judge's emotional tone, combined with the legal consequences, creates a powerful courtroom confrontation that will strongly engage viewers.